Hello and a very warm welcome to everyone that is watching LawPutra. My name is Ananya and today we will be discussing about Section 249 of the Criminal Procedure Code 1973. Section 249 talks about the absence of the complainant. But before we move on to the section itself, first we need to understand the placement of this section in the code. So it finds mention under chapter 19 of the code, which deals with the trial of warrant cases. And as you all would know that warrant case as defined by section 2x of the code would mean any offense that is punishable with death, life imprisonment or imprisonment that exceeds the term of 2 years. What's also important to know is that Chapter 19 is divided into 3 parts. The first part deals with warrant cases instituted on police report, and sections 238 to 243 deal with that. Now part B of chapter 19 deals with warrant cases instituted otherwise than on police report, which means essentially cases instituted upon complaint. Sections 244 to 247 deal with this. And the last and final part, that is part C of chapter 19, deals with the conclusion of the trial. And 248 to 250 other sections that deal with such provisions. Now that we have understood what are warrant cases and what are the types of warrant cases, we can move forward to understanding what exactly section 249 talks about. Section 249 deals with the procedure that the court has to adopt in case of absence of the complainant on the date that the court has given to the complainant. 249 provides that if the complainant is absent on the date that the court has decided or fixed for the hearing of the case, then the magistrate shall have the discretion to discharge the accused. But there are 4 conditions that need to be fulfilled in order to exercise this discretion. The first condition is that the offense must be compoundable. A list of compoundable offenses has been given under section 320 of the code, and all the offenses that are not given in that list, all those offenses will not be compoundable. The same has also been mentioned under the same section, that is 320. The second condition is that the offense should not be a cognizable offense, meaning the arrest of the accused should have to be on a warrant or with the permission of the magistrate, and if the offense is such wherein the arrest of the accused can be done without a warrant, in that case section 249 will not apply. The third condition is that the case must be proceeded upon or instituted upon a complaint. It must be a complaint case. And the last and final condition would be that the charge for the offense must not be framed. So discharge can only happen before the charge is framed, and hence the charge should not be framed. If all these conditions are satisfied, only then the magistrate shall have the discretion to discharge the accused. But a discretion would mean that the magistrate may or may not discharge the accused. It means the magistrate may or may not proceed with the case. And if the magistrate decides to proceed with the case despite the absence of the complainant, he is well within his power to do so. A very important case from the year 1966, the name of which is Ashwini Kumar versus Durijan Dey, also provides with that. A question that arises in our minds over and over again is that if the charge is framed, can the magistrate exercise his discretion and discharge the accused? The answer is no. If the charge is framed, there cannot be any sort of discharge in that case. In the case of Laipal Singh versus Manipur administration, the case of the year 1962, it was held that even if the complainant dies, section 249 will still be applicable. So even if the complainant dies after framing of the charge, the magistrate is obligated to follow the procedure and proceed with the case. One more important thing to note about section 249 is that it is not a decision on the merits of the case and does not hold the value that a judgment would. The discharge under section 249 is merely on technical grounds and not on merits, and this has to be kept in mind. The discharge under section 249 is vastly different from the discharge under section 245. The reason is that under 245, the magistrate sees the evidence and decides whether a case is prima facie made or not, whether the charges that are being put on the accused are baseless or groundless. But there is no such application of mind, or there is no looking of merits of the case. This discharge is merely on technical grounds, and this thing has to be kept in mind. And with that, we have covered all the important points and cases regarding section 249 of the CrPC. And I really hope you enjoyed watching this video and that I was able to contribute something to your knowledge. Keep watching LawPutra and have a great day.